If you're watching this and care about how 19th century laws continue to shape 21st century lives, now is the time to stay engaged. Subscribe, stay informed, and stand for what you believe in. Because court decisions like this aren't just about laws, they're about the world our children will inherit. In a landmark decision with sweeping implications for reproductive rights in the post-Roe era, the Wisconsin Supreme Court today struck down the state's 176-year-old abortion ban. In a 4-3 ruling, the court's liberal majority concluded that newer state laws regulating abortion, especially those passed since 1985, have superseded the near-total prohibition first written into law in 1849. That 1849 statute, passed when Wisconsin was still in its infancy as a state and decades before women had the right to vote, criminalized anyone other than the mother who intentionally destroys the life of an unborn child. Though it was dormant during the Roe v. Wade era, conservative voices insisted that the 2022 Supreme Court reversal of Roe had resurrected the ban. But Attorney General Josh Kaul, a Democrat, took a different legal stance, arguing that modern abortion regulations, including a 1985 law that allows the procedure until fetal viability, around 21 to 24 weeks, render the old ban obsolete. His lawsuit formed the basis for today's ruling, which now provides long-sought clarity to clinics and patients across the state. Circuit Judge Diane Schlipper, who initially ruled on the matter in 2023, interpreted the 1849 law as banning feticide, the non-consensual killing of a fetus, not consensual abortion. That distinction had already opened the door for the resumption of abortion services in Wisconsin, but the Supreme Court's decision today cements it as settled law, at least for now. Writing for the majority, Justice Rebecca Dallett emphasized that comprehensive abortion legislation passed over the last 40 years has effectively replaced the antiquated 1849 statute. In plain terms, the court found that modern laws, including detailed statutes on who, where, and how abortions may be performed, nullify the old blanket ban. In a sharp dissent, Justice Annette Ziegler accused the court's liberal justices of imposing personal beliefs over judicial principle, calling the decision a jaw-dropping exercise of judicial will. Her critique echoes a broader conservative backlash to the ruling. The case was brought directly to the High Court after Sheboygan County District Attorney Joel Urmansky, a Republican, sought to overturn Judge Schlipper's 2023 ruling. Urmansky argued the old and new laws could coexist, likening them to different penalties for the same crime. The court rejected that interpretation. Though today's ruling will certainly reverberate through state and national politics, it is far from the end of the legal battle over abortion access in Wisconsin. Another lawsuit from Planned Parenthood of Wisconsin challenging the 1849 law's constitutionality remains pending before the High Court. Newly elected liberal justice Susan Crawford, who defeated a conservative opponent in April but has not yet been sworn in, did not participate in today's ruling. When seated, she is expected to solidify a 4-3 liberal edge on the court until at least 2028, setting the stage for more ideological clashes in the years ahead. What happens next in Wisconsin may very well influence legal strategies and legislative agendas in other battleground states still grappling with pre-Roe statutes. Today's decision is not just a state-level policy reversal, it's a signal that the judiciary will be a frontline arena in America's ongoing abortion debate.